Hello, this is Elliot Schlissel. Today we're going to talk about what is required with regard to making of a will. There are a number of requirements necessary to write a will. First, you must be of sound mind. You must understand what you're putting into the will. You must understand who your next of kin are, what your assets are. You must be over 18 years of age. When executing a will, you must state that this is your will. You must acknowledge to the individuals witnessing your will the document in front of you is your will. You must sign the will at the end. The will must be attested to in the state of New York by at least 2 witnesses. Usually 3 are used in the execution of a will in case one should die or be unavailable. The witnesses should be neutral parties and not beneficiaries who receive inheritances under your will. Witnesses to the will must see you sign the will at the end and hear you state that the document is your will. Thereafter, the witnesses must sign the will after you sign the will and sign the will in front of each other. If you have children, the will should appoint a guardian for your children in the event they are minors. This way someone will be available to take care of them in the event of your death. You should specifically identify what your assets are in the will and state who you would like to inherit them. Assets not specifically referred to in the will should also be distributed by the will. This should be distributed under a general clause at the end of the will, giving the rest of your assets to those individuals you want to receive them. The will should also appoint someone called an executor. This is the person responsible for supervising your burial, the gathering of your assets, and the distribution of your assets.